some slides to provide some context around this conversation. I can move forward because you've seen this for half an hour now, and also ask some additional questions. So the first, why are we spending so much time on international transfers in general and here as well? And really, this has been part of the conversation for decades. From the very beginning, international transfers have been discussed in the OECD, Council of Europe. And in a way, it's a logical consequence of also the exercise to seek more harmonization, more consistency. If you concentrate on a certain area, then logically the question comes up how that area interacts with surrounding environment. So that is the dimension to ensure that protection is not avoided, circumvented, and others refer to this as the continuity of protection. I think in truth it is seeking compensation for what is an unavoidable effect. If data move outside, there's going to be a loss of protection, but how can we compensate for this? Now, in the age of globalization, that is of course even more relevant, and this is why we're now also thinking, in the context of the review, about the scope of our protection, the primary protection, the scope of the regulation, and on how the interaction with third country jurisdictions takes place on that context, transfer and otherwise. To add on to all this is of course the growing impact of the Charter. If data protection is a fundamental right and should be developed in practice, should be provided in practice effectively, then how do you deal with loss of protection due to increasing globalization and data need to move? That is the unavoidable dimension. So I think it's natural to deal with this paradox. You need to be pragmatic, both principled and pragmatic. And the current system shows pragmatism on different levels. First of all, we should not underestimate this, that is the recognition of the terminology, equivalence within the area of protection, within the EU, within the scope, and that is bound to increase. But interaction with third countries, the word adequacy was introduced. That's not the same, and we should not make it the same. Otherwise, I think we lose part of the balance. But adequate should be adequate under the circumstances. Another thing is there's adequacy in shades and forms. There is the adequacy general, recognition the system is systemic adequate, and there is the adequacy specific, ad hoc or tailor-made, however you want to refer to that. And then there is the limited list of exceptions, which also, via the back door, insist on the need to provide protection. So it's keep it narrow and think in terms of protection general. Now, what is important is that in spite of the review, very basic, thorough review, I think the structure approach will be the same. There is a lot of detail, but I would say this pragmatism, the different levels, will be the same. There will be more solutions for adequacy in specific circumstances. And so, as you know, the scope has been extended. There is a way to look at this. I think this is the architecture of European contribution to interoperability of data protection frameworks. Building on all those options is the way to engage with third countries.